Hello everyone, this is King Bay. Today I'm going to drop some powerful information. I'm going to show you a method and I'm going to use child visitations in a form that you can get a contempt if your child mother is not in compliance with the rules. So this is for brothers who paying child support and you would like to see your children. I advise that every man who pays child support, see your children. Just see your children. So before I get started, let me go ahead with this disclaimer and then we'll get into some more information. So um, just to like to tell everyone, um, I'm not an attorney. This is for educational and entertainment purposes only. And please be advised. If you're looking for um, legal advice, I can't give you legal advice. And also, find you a competent attorney if you're seeking yourself legal advice. So, with that being said, we're going to keep it pushing, and I'm going to go through this information in this video. So, also, if you're having child support problems, go get How to Stop Child Support by King Bay, the Must Child Support Manual, Volume 1. I'm putting together a series, so get the book. It got so much powerful information in it. Check it out. Get the book, and if you have a child support, this could give you some. This will give you a lot of valuable answers that you need to help you get rid of child support. So let's keep it pushing. Um, the first process I want to talk about is called a notary. It's called a notary protest and dishonor. But before, I like to mix this with this through a notary presentment. And a notary presentment is where the notary present the information or the complaint, in which the notary you give the notary a sign off on everything, and the notary attests everything for you. So in the document, the notary will also, they normally have some examples up here. The notary also verify that they are do a certificate of service of mail and all of that through the notary presentment process. The notary will be the one to verify all of this, and the notary is a official officer of the court. It's a notary is an officer, so the notary will be able to verify. And once the notary has done this, can be concluded as evidence, because the notary is a witness and an officer of the court, in which it can, all this information is now validated. Just want you guys to understand that. So let me jump back over here. So with the notary presentment, I do this and then I package this in there. A lot of people, notary protest and dishonor, you don't have to necessarily do it particular this way. But I like to do it a notary protest and dishonor um, in a particular fashion. So when you dealing with your baby mom, let's say for example, you paying your child support, you have a visitation order, and she's non-compliant. So you will start using this process to get a contempt on her. Don't worry about the judge if they rule in your favor or not. The thing about this process is this is going to speak for itself. If she failed to answer, she failed to do anything, she failed to do, she act like she ain't got to be bothered. All of this stuff will come in handy and you will get your remedy. So the first thing I do is a notary protest in dishonor of the court order, and just explain it. Boom, boom, boom. Start going through and explaining that on such date, this is the time, such you have failed to appear, blah blah blah, whatever. And then you have the notary attest to it. You have a notary attestation, blah blah blah. She's going to attest to everything on a separate sheet of paper. Okay? And yours is going to be in the form of an attestation and a complaint. It's going to be in the form of attestation in dishonor. And I did videos. You're going to plead under penalty of perjury without the United States. And then you're going to have her do on a separate document the notary presentment with the protest and dishonor. Okay? Then you're going to take it, and once she sign off on it, you then going to get it authenticated by state or county to verify that that is a true notary. The notary is going to attest to everything that you're saying is true. Okay? The notary is going to be your backup when you attest to everything. Okay? Now, if you got videos or whatever, let the notary see the video. Let the notary attest to the information on the video. Okay? The video, the notary now is going to attest what's on the video, and it's going to become credible evidence. You have to understand everything boils down to evidence. I'm going to say this. This is probably the most powerful process that I ever seen being used. And if you do it on a, like, as it's time required, because everything in law is time sensitive, you don't want to put yourself where you can't use this process due to an order already had surpassed. And now you can't go back and change the order. But if you use this correctly in a timely manner, and you do this in the very appropriate to the rules, and you do it like you're supposed to in a time that's required, you can get your remedy if you do it right, if the person fails to do what they need to do. So, for example, once you get this done, once you get this process done and then you send it off, she don't answer, you do a notice of default with the opportunity to cure, blah blah blah. You stated all the stuff in there. You failed to respond. This is going to look as a default, and it look like it's going to be contempt on the basis of your behavior, failure to respond, and give me adequate information why you failed to be there for visitations as required by the court order. Blah blah blah. Even send attached of a copy of the court order. You get what I'm saying? So while you doing this information, you make sure that you spell out everything. She failed to answer again. You go ahead, hit it with a default and and then you say, well, you are now at default. You have an opportunity to blah 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 to cure the matter. Please respond. Blah blah blah. Then next thing you know, you hit her with a judgment, and you state the facts. You have the notary sign off on this. Blah blah blah. This and everything that's regarding the circumstances why she's a dishonor, why the judgment, and you want it to be upheld. That now you are in contempt, and that now you requesting for relief of this, and now you get ready to go to the court. Once you get all this stuff, your records, they're going to be authenticated, like I said, by the county or the state, showing that it's a true notary. And the notary, through the notary presentment, has verified everything that went out. Is going to state it in her attestation that everything is true, blah, blah, blah. And now you can take all of that and present that as evidence. You can file your complaint, or you can do this like a lot of times what I would do, I would file my complaint first. And because you're gonna probably get a 30 days, you ain't gonna go to court for at least, most of the time for me, 30 to 90 days. I wouldn't be in the court. Most of the time it'd be like 2 months, 60-day period. I wouldn't, any complaint or anything I file, I wouldn't be heard for. And that was it on that matter. So once you get there, you know, like I did this, the judge wanted to do a mediation hearing, and I told the judge, I don't want to do the mediation hearing, but she forced it on. But I asked her about my contempt. I said she's tampering with my weekends in the court. So what they did was they gave me 2 additional days. They said, well, we're going to make up for it. I said, you can't make up for that time. I said, she's being dishonored, and she's not honoring the process, but she wants child support every month. So we went back and forth. The judge did that. We went through everything. So that was evidence. So it was on the record. We go back and forth. They didn't hit her with a contempt right off. The judge told her if she do it again that she's going to hit her with a contempt. But you got to understand, I build up evidence, went back to court. She did it again, went back to court. But this time with this information, now the court ready to give her a contempt on this one. Now they said, okay, we're going to stop playing games and start getting serious. Then she went ahead and started complying with the rules, because they hit her with $100 fine. And that's when it started getting serious. That's when she started shaping up and allowing the process to go through. But you got to make sure you get this process correct. And this is the most powerful process, and it'll work in all situations, from criminal to majority of your civil. It'll work in all situations, civil, criminal, you name it, traffic, all of it. It works. You just got to know how to do the process and do it in the time frame that it's need to be done. And because you can be barred from doing it once certain things happen, the proceedings start to happen, then you will have to go through the discovery process and other stuff. But the notary presentment is one of the most powerful processes that you can utilize. Okay? But I also want to identify something with you guys. Now, in my state, let me get this right. There is, we have family court. It's the court of domestic relations, right? This is not the same as juvenile court. Juvenile court is where they hold child support hearings and they deal with juveniles. Family court is not that same court. So they're two different courts. These are for domestic relations. They do handle visitations, but that ain't where you want to be. You want to be over here. Also, the domestic relations deal in the civil rules of procedure. Okay. Juvenile court has its own juvenile rules of procedure. So you also got to check within your state, your boundaries, how your state set it up and how the state is operating in their jurisdiction. For us that, I don't know, every state has it different. Also, let me go back. Let's talk about the contempt. Now, a person is guilty of any of the following may be punished as contempt: disobedience or resistance to a lawful writ process order. Here's an order. You have a court order for visitation, rule, judgment, or command of a court or officer. So this is what you got to look at. Now, in my state, they also have this, and they also have this. This is also applicable. Contempt for actions to fail to pay support or comply with the parental time or visitation order. Now, we're going to skip the child support, and then we're going to go here. The parental time. Any parent who is granted parental time, rights under a parental time order or decree issued pursuant to this section. Any person who is granted visitations under a visitation order or decree pursuant to this section. And these are all under the family court, if you were in my state. Pursuant to any other provision of the revised code, any other person who is subject to parental time or visitation order or decree may initiate a contempt action for failure to comply with or interfere with the order or decree. So when we go back here, this notary protest, along with this notarial presentment where the notary is sending it off. I want you to understand, you're not sending this off. The notary is mailing this for you, and the notary is receiving the mail, and the notary can verify everything as an officer of the court. I want you to understand this. This is very powerful. If you do it the way that I'm telling you, this is a very powerful remedy. And this, let me show you something about this. I'm going to show you something. In commercial redemption process involving notary public and a commercial dispute is for the purpose of gathering credible, admissible evidence of dishonor for resolving a dispute. A notary public is a public officer with the government and as such their official records are considered public records and are exempt from the hearsay rule under federal rules of evidence. Also under your state rules. So let's go under the rules of evidence. And I just want to show you guys something. Where was it at? Was it 802? Why did it go there? Show you guys something. Okay. Hearsay rule exceptions available of declared immaterial. The following are not excluded by the hearsay rule, even though the declarant is available as a witness. So I want you to look at this. Um, Recorded recollection, mental, let me see. Public records and report. Records, report, statements, and data compilation in any form of a public office or agency. The notary is a public officer. Setting forth the activities of an office or agency or matters matters observed pursuant to duty imposed by law of which there was a duty to report. Exclude, however, in a criminal case, um, criminal cases matter observed by police officer or other law enforcement unless offered by a defendant, unless the sources of information or other circumstances indicate lack of trustworthiness. So I want you to know that the public notary is a public officer and her stuff is enforceable, and it creates trust. It creates trustworthiness. So this is the way to do it. Now let me also show you this. Go down here, and I didn't show this in the videos. Self-authentication. Let me show you something. It did it again. Let me show you this. Self-authentication. It says acknowledged documents. Documents accompanied by a certificate of acknowledgement executed in the manner provided by law by a notary public or other officer authorized by law to take acknowledgement. It's considered to be evidence. Self-authentication. Intrinsic evidence of authentication as a condition preceding to admissibility is not required with respect to the following. So I'm telling you a process. Once this is done in the appropriate manner, this now becomes evidence before the court, and the judge is irrefutable evidence. The judge cannot disgrace the evidence. And if you like me, I would give more than one witness, even to go in with the notary presentment to testify, and have that even authenticated even further to even strengthen the process. This is the game changer. So I want you to know. Let me see. Trial, jury, discovery. So you put in your motions, just going through it. You get your remedies, and now you can ask for the court for injunction. If she keep doing it, you can ask for a change of custody if that keep going on. So let me go back to the statute. Let me see where the penalties lie. So it says the imposition of any penalty for contempt shall not eliminate any obligation of the accused to pay or pay any past, present, or future obligations or obligations accused to comply with a refrain interfering with the parenting time or visitation order or decree. The court shall have jurisdiction to make findings of contempt for failure to pay support and impose penalties set for this. Let me see. Interfering with parenting time or visitation, it may impose set penalties under this section. And revised code cases which failure to interfere is a issue even if the parenting time or visitation order or decree no longer is in effect. So let's look at this. Hearing penalties, duty, and garnish sheet under support order. Um, so here we go. In all contempts, the court shall conduct a hearing, investigate. That's why I say you want the notary. If the accused is found guilty, the court may impose any of the following. First offense, a fine, $200. A definite term of imprisonment not more than 30 days, or both. Second, a fine not more than $500. A definite term of imprisonment not more than 60 days in jail. A third, a fine no more than $1,000. A definite term of imprisonment not more than 90 days. Now, while all of this going on, listen, you can get a change of custody order. If she's in contempt, you can ask for a motion due to a change of circumstances and due to the fact of contemptuous behavior and start operating in the process. So those who really need this process and really need to understand how this works need to understand these are the things you have to know. So by me being a litigator for the length of time I have been, I understand this process in its entirety. So for those who need help, who's having visitation issues, who's having all other types of issues, give me a call. Child support. I'm gonna show y'all some more little tricks of the trades with child support, and I'm gonna break this down for y'all so y'all can really get it. You know, when it comes down to this procedure and practice, we do this. Get this information. I'm gonna do these videos, and then I'm gonna probably stop. You know, I'll probably let these videos circulate. You know, but those who need help, I will help you. Give us a call at this number. Let me show you guys. 513-549-7270. 513-549-7270. Ask for King L. Bay. I'll be glad to help you. And I'll drop this information to you guys like it's nothing. I will give you guys this information and show you guys what we're doing in the future. We got some very good stuff we're doing at Must, and like I said, we do asset protection for us with the trust. We show you how to be a secure party. We understand the creditor process. We understand how to build credit. We understand how to get from up under certain jurisdictions, and we'll teach you how to protect your assets from credit vultures. This is King L. Bay. I wanted to give everybody peace and love for watching this video. I'm out. Peace.